Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from an organisation called Policy Press, which is part of the University of Bristol. The title is Inside Crown Court, and it's got a subtitle, Personal Experiences and Questions of Legitimacy, and it's been written by three people, Jacobson, Gillian and Amy Kirby. We'll have a look at the book in a minute. This book is an important one because it's basically following a survey, a collection of papers, which have been put together to give us a picture of what's going on in the Crown Court. We don't get very much information about this particular court and its functioning, so this is a very welcome book. Let me show you it first of all. It's a hardback. There it is. There's the front, the spine, and then the back. It doesn't run to that many pages, but there is at the back quite a useful index. You can see it there. It runs to something about just under 250 pages. It's also got a very important appendix, which is actually about the various surveys that were conducted, the questionnaires. Now at the front you've got the main title page there. Then you've got an epigram, which is an interesting little statement, going back in history a little way. Then you've got the 8 main chapters, the introduction and the conclusion, and the appendix listed. Then you've got some acknowledgements there. Then you go straight into the introduction. There's no paragraph numbering. There are subheadings, which are quite useful. There's no footnoting either, just going to the centre of the book here. Them and us. The divide between court users and professionals. As I say, it makes for some interesting reading. You'll find that the notes connected with the actual chapters are at the back of each chapter. So they are effectively footnotes, but you can find them there. There's also a very useful bibliography. It's called References, but it's actually the bibliography. It's there. Now, I saw this book and I thought it was well worth reviewing because there isn't that much by way, as I say, of information about the Crown Court. And having spent my formative years as counsel in that court, it's useful to see the way it's been developing, and in fact the shroud of mystery, if you like, which envelopes it to a certain extent, or engulfs it really. I think this is very important because we do need to make the public aware of what goes on in these courts, and public education is an important area. I'll come on to that in the review. Now, Elizabeth and I have written a review, and we gave it the following quote as the introduction: an in-depth examination of the arena where serious criminal offences are prosecuted and sentenced. And this is basically what we say. There are not that many publications available today which have examined in detail the working of the Crown Court since its establishment in the 1970s. So Inside Crown Court is to be welcomed as it presents the findings of a 20-month qualitative study of the Crown Court, which was funded by the Economic and Social Research Council. They do mention it, and they call it, in fact, an up-to-date ethnographic research. That's how they put it. I'm not going to use those words. I'm going to try and keep it a little simpler, because this book has got applicability across the board, not just for professionals and the users, but I think the wider public. We're not at all surprised at the findings in this book, and the final chapter, which is chapter 8 on conclusions, sets out what both advocates and the general public would find of greatest interest, we think. The three authors, I mentioned them, Jacobson, Gillian and Amy Kirby, state that the greatest challenge, quote, lies in the fact that defendants' marginalisation and passive acceptance are likely to have roots much deeper than the way the criminal justice system operates. And I'm afraid they're right there. These are probably the key findings which give the book such relevance and resonance for current applied criminologists, researchers and those involved at any level with the Crown Court. I think the important thing to bear in mind here, when we talk about defendants' marginalisation and passive acceptance, it's because it's a criminal high court, effectively, And you therefore do have a very different approach from perhaps the approach you might have in the civil courts. And there is this mystique which we do need to look at in a little more detail, I think, because the public get the wrong idea of the Crown Court from what's on television, and that does actually jaundice the view. Let me continue with the review though. Between the years 2005 and 2010, some limited government research was conducted into the experiences of court users, and I can remember the forms we were asked to fill in when I was at court. Unfortunately, the cuts that have taken place have resulted in the shelving of much valuable feedback, although we do have the Witness and Victim Experience Survey, WAVES, which was initially established, and I hope it's going to be continued and perhaps restarted after the general election, because of continuing concerns about the position applied to victims within the criminal justice process as the issues sort of continue to rise up the political agenda. You get a lot of these cases mentioned on television, and I think it's important that we look very carefully at the role of the victims. That's certainly what this current Parliament's been doing, and I would think that will continue with the next Parliament in May. In essence, Inside Crown Court is a research book which will be of great value to a wide range of readers, both legal and general. It should be read by all users of the system, as well as undergraduates, academics, and I would suggest Home Office and Ministry of Justice policymakers and legal practitioners, because again, that's another area where I think they would benefit from looking at this research. It's particularly relevant to criminologists, as probably the foremost research at the moment in terms of paper research on where we've come with the creation and operation of Crown Courts in the last 40 years. And I of course go back to before the Crown Courts were in existence, when we had the Court of Sessions and Assizes, which ages me a little bit, I'm afraid. The book runs to about 250 pages and has 8 chapters. The crucial chapter for counsel is chapter 5 on structured mayhem, which just about sums up some of the chaotic and frankly unprofessional way, in which the court proceedings appear to be conducted. Talleyrand once said of the Bourbon kings of France that they had learned nothing and forgotten nothing, and we feel this possibly is an apt summary of the state of the Crown Court today, where there is an urgent need, in my view, for immediate reform. And there are a lot of things that can be done. It's to be hoped that the current reshaping of justice under the initiative set up by the Lord Chief Justice, Lord Thomas, which began in the spring of 2014, will pay some attention to the findings of this survey and actually learn something which can be constructively used from the excellent appendix which details observed cases. The day will come when all proceedings are video recorded, possibly not for public consumption after things like the Pistorius trial and what happened there and its implications, but we might just as the public see some meaningful changes. As I've said before, I think this is an important area for public legal education. Let me conclude by saying it will be a tribute to the 3 applied criminologists who wrote this book if some of what has been highlighted can be acted upon after the 7th of May 2015. We'll wait and see. Meanwhile, as I've said, this book is a great example of why we need much more public legal education on what we as practitioners do. Inside Crown Court is a great start on this new road if an incoming government grasps the nettle. So there's a bit of a challenge there set down. I think it's important for us to bear in mind what is going on. There's the book again on the back, just opening it up. It's an important area, legitimacy. This is the one area I was talking about. Legitimacy, court users' perceived obligations to obey and what this is based on. And again, this is very much part of the quote on passive acceptance and so forth. And just remember the notes. It's been very well researched. I can see they put a huge amount of effort in, and there are a lot of relatively new points. I'm sure anybody at the criminal bar will find it very helpful. I'd like to thank the 3 authors and the University of Bristol and Policy Press for producing what I think is an excellent survey. It should be on the reading list for all undergraduates, and certainly it should be on the bar course and the Law Society courses for the future. So thank you to all concerned, and good luck with your future endeavours. Bye-bye.